Hi everyone, my name is Hannah Rowland and I am an owner of Orbit Wills. I get questions all the time about whether a will or a living trust is right for my customers. And a lot of people will be talking to their friends and family and they'll be talking about trusts, and while they work for a lot of people, they may not be right for everyone. Today I'm here to break down the differences between a will and a living trust and which one might be right for your family. I'll also be busting some myths along the way. As always, I'll be talking about Washington state law specifically. So let's get into the basics. Okay, so the first question is, what does a will do? A will is a legal document that directs assets in your name to where they go after you've died. A will appoints your executor, or the person that will actually be executing the will. So you have a legal document where you appoint your executor and you distribute your assets. A will makes the probate process much easier. A common myth is that because you have a will, you're avoiding probate, and that is just not the case. Like I said, a will makes probate easier, but it does not avoid the process. At this point, we're gonna have a quick primer on probate because it's necessary to this discussion. So probate is the court process of getting assets out of a deceased person's name and into the beneficiary's name. It is a court process, which means it's public, and it also varies greatly state to state. So while it may be manageable in some states, it could be very long and expensive in other states. Also, it's important to know that probate is more work generally than a trust administration, which I'll be talking about a little bit later. But you can think of a will as your instructions to the probate court saying, this is who my executor is, and this is where my assets go. Next, we're going to talk about what a living trust does. And I'll just start by saying there are tons of different kinds of trusts. But when people talk about trusts, when they're talking to their friends or their families, they're usually talking about a living trust or a revocable trust, which you can think about as an alternative to a will. A living trust is a vehicle that holds all your assets while you're living, and you are appointed as the trustee and the beneficiary. That means you control all the assets, and you can use them however you want during life. After you've died, those roles change. The trust dictates who is in charge, the trustee, and who benefits from those assets, the beneficiaries. And there's no need to go to probate court to say who's in charge and where those assets go, because the trust document itself already does that. So the trustee will have access to assets that are held by the trust and can distribute them directly from there without needing to go to court. An added benefit of a living trust is that it avoids probate in every state that you own real estate. It is really important to remember, though, that the sole purpose of a living trust is to avoid probate, that there is no asset protection and there is no tax benefit just by putting assets in a living trust. A lot of people will say to me, well, my assets are in a trust, so that protects me from a lawsuit, right? That is not the case. It depends on the terms of the trust. And specifically for a revocable living trust, there is no asset protection. So a living trust only works to avoid probate if all of your assets are titled correctly. So the vast majority of your assets will need to be titled in the living trust, but there are certain assets like retirement accounts that cannot be titled in the trust. But let's say you die and you have a living trust, but your assets aren't titled in the trust and they don't have beneficiary designations. We need to go through probate to get those assets in the trust, to get them where they need to go. So retitling your assets is actually going into either the title office, executing a deed, going into the banks, and making sure that the owner of the asset, bank account, investment account, real property, is you as trustee of your living trust, not yourself individually. If you own an asset individually when you die, we will be going through probate to get that asset where it needs to go. In summary, instead of your assets being transferred through the court, the trust document itself specifies where the trustee can distribute your assets. There is no requirement to go to court with a living trust, assuming everything is titled correctly. Because there's no requirement to go to court, everything is private. This usually means that the administration process is less costly and less time-consuming for the trustee. It also means that there's less need for lawyers during the administration process. So now let's compare and contrast the two. A will goes through probate. A trust avoids probate, assuming everything is titled correctly. A will is public record. A living trust is private. In terms of work and cost, a will is less expensive now. It also doesn't require you to retitle your assets. That being said, it is more work and more costly after you've died because of the probate process. But because you have a will, it again streamlines that probate process. A living trust, however, is more costly and more work while you are living, but the idea is that you're front-loading that work. So your beneficiaries and your trustee will not need to do it and will not need to go through the probate process after you've died. At this point, you may be thinking, well, which plan is right for me? And I will say a will is a great option for people that don't want to retitle their assets, would like a good estate plan to make the probate process a lot simpler, and don't want to spend the money to put a trust together. And trust might be more appropriate if you have out-of-state property, or you're concerned with privacy, or you'd like to spend that extra money and take that extra step to make the administration process easier for your families. I consider a will absolutely essential for everyone over the age of 18. A trust is nice to have, but a will is necessary. Another common myth that I hear all the time is, well, I have a trust, so I'm gonna avoid probate. And that's not necessarily the case if everything is not titled in it. So remember, it's important that real estate, bank accounts, non-qualified investment accounts are titled in the name of your living trust in order to avoid the probate process. There are specific accounts like retirement accounts that should be out of the living trust, should have beneficiaries on them. But remember, this applies to your assets in the future indefinitely until you've died. So if you acquire new real estate in a different state or in this state, you have to make sure that it's titled correctly. So I know this is a really confusing topic, so if you have any additional questions, make sure to leave them in the comments. And don't forget to like and subscribe for more estate planning information.